Well, good morning, Houston. My name is Nancy Herzig. I'm a contract instructor here at the Houston Association of Realtors. And today we're going to try to get some information to you about the relatively new requirements in the Licensing Act and in the TREC rules having to do with our very own names, would you believe, and how they fit into the advertising requirements. Changes in legislation happened way back in 2017, and those changes affected the TREC rules on the names in advertising, part of which was it repealed a former requirement that the license holders identify their status as a sales agent or broker in an advertisement. That means that we no longer had to say our name and where we were in the organization, whether we were an associated broker, whether we were a sales agent, whether we were a real person, whether we were the mail clerk or the receptionist. That went away. They could not require us to do that. But of course, the Code of Ethics does still require that we do that. It clarified about advertising and what makes it misleading. It really goes back to some confusion that happened with the onslaught of team names, and we'll cover that more as we go. But an advertisement is said to be misleading if it fails to identify the name of the broker, implies that a sales agent is responsible for the operation of the brokerage. That goes right back to the confusion about teams. And it limited TREC's authority to adopt rules requiring the license holders to identify themselves by use of the term broker or agent. Further, it limited TREC's authority to require any reference to the commission or license number in advertisements, but agents could still do that. And there was a rumor or whatever years ago that TREC was going to require sponsoring broker's license number to be on all advertisement. Well, this limitation took that away. As we go through, you're welcome to enter any questions that you might have, and we will stop occasionally to review those questions and get answers out to you. That being said, let's go ahead and get started here. So the legislature back in 2017 did some things that caused TREC to pause. TREC took a really hard look at the TREC rules and determined that some of those rules were so old and so convoluted that they really needed to be clarified. Nobody could really understand what they were trying to say. And interpretation of some of those rules was confusing, and so they went through and they changed some of the rules based on the directions from the legislature to update, interpret, and kind of balance the statutory requirements to protect the consumer from being exposed to misleading advertisements. They modified Rule 535.154 to remove references to advertising, and so that rule just went totally into names. It provides for the registration and use of alternative names, team names, and assumed business names in advertising. And it identifies the different kinds of names used in advertising, how to register those names with the commission, and whether the broker or the license holder is responsible to notify the commission. And we'll talk about that as we go, as who does what and how you do it. And then a new rule was established. It was 535.155 that refers only to advertisement. And it talks about the definitions of what makes an advertisement, use of names identified in the other new rule, and offers about 20 scenarios which constitute a misleading advertisement. Now, of the 20 scenarios that constitute a misleading advertisement, most of those have been in the rule for a long time. Later on this morning, we're going to talk about the 3 or 4 of those that are new and that will affect us as we go forward with our advertising. First things first. What the purpose of all this name stuff is to assure that the Texas Real Estate Commission can find us. So if a license holder uses the name on their license exclusively throughout their career, they're good. They're compliant. TREC can find them in the database. But sometimes a license holder wants to use a name other than the name on their real estate license, and they may or may not have to notify TREC of the change. The key question is whether TREC can still locate you in the database if you change your name up a bit. So let's take an example. Say the license holder's name is Elizabeth Marie Johnson. She wants to use the name Liz Johnson. Liz is a common derivative of the name Elizabeth, and that's okay. So probably she can use Liz in her advertisement with no problem from TREC, because if they look up Liz Johnson, they can find her. Now say she wants to use her middle name, Marie Johnson. What do you think? You think they can find her? Probably not, because she's trying to use her middle name as a first name. So in that particular case, all she needs to do is file an alternative name with TREC, and that will make things clear. So if anybody looks up Marie Johnson, they will find her. Finally, nicknames that are not a derivative of the license holder's name will need to be reported to TREC and to the license holder's sponsoring broker. Something like Skip, Lucky, Blondie, Junior, all those kinds of nicknames. There is no way that a license holder can use those kinds of names instead of their registered license holder name and have the commission be able to find them. So, given that, let's just take a minute and talk about the different kinds of names that we're going to be dealing with today. First of all, an alternative name, also called an alias, is a name that an individual license holder would like to use other than the name shown on the license holder's license issued by the commission, such as a maiden name, nickname. It does not include a common derivative of a name such as Kim for Kimberly, Bill for William, which is considered the same as the name on the license. A request from the license holder is used to use a name other than the name on the license holder's real estate license. And before a license holder starts using an alternative name in advertising, the license holder must register that name with the commission on a form approved by the commission, and I will show you that form in just a little bit. So as an example, if a woman is getting married and she wants to use her maiden name as a middle name, she would have to file an alternate name registration with TREC. If she wants to hyphenate her name, she would still do the same thing, but then she'd have to do a change of name also for the change of the last name. And if it's a change of the last name, the commission will request documentation that evidences the legal authority to use the alternative name. And if you stop using that alternative name, there's a 10-day limit that you must notify TREC after the date you stop using that alternative name. So alternative names is just if we want to use something other than the name that's on our license. It's pretty simple. The license holder is responsible for doing it themselves and notifying their sponsoring broker of the change. Associated brokers. An associated broker is a sales agent with a broker's license who associates with a sponsoring broker. And that is intended as a continuous relationship. Most independent brokers who work under another broker use the phrase associate broker to identify their status. That's an acceptable term. Everybody does it. Most of the time we find that term. TREC, for some reason, however, prefers to use the term associated broker. An assumed business name is also a DBA or trade name. This is what sponsoring brokers use and allow their sponsored sales agents and brokers associated with them. So if you work for a XYZ broker, you are allowed to use that name as part of your identity. Most commonly used in franchise brokers, however, each is identified by the parent company plus the franchise company. So if it's a Keller Williams brokerage, as an example, it'll be Keller Williams Realty and then the name of the independently owned franchise. The broker registered assumes names with the commissions. And assumed names can be used and issued to sponsoring brokers only. By definition, license holders who wish to do business under a name different than their license name must do so by establishing a team. Now, on the assumed name, sponsoring brokers can have many assumed names, and they can assign certain agents to be able to identify with certain of those assumed names, such as if the sponsoring broker has a property management company, he can have an assumed name for the property management company, and he can allow only the agents that are authorized to do property management to identify with that particular assumed business name. Teams. A team name is a group of one or more license holders sponsored by or associated with the same broker, and a team is a group of people who work under a sponsoring broker. In the beginning, when teams became so popular, some of those teams were registered with the commission as broker assumed business names. And that became inappropriate under the new legislation because it caused confusion with the consumer, because it looked like the team was on the same level as the broker and the team is subordinate to the broker. And so they made some changes. They said that team names cannot contain words that would lead a consumer to think that the team leads the brokerage, such as brokerage, company, or associates. Those are forbidden words for a team. And they added the requirement that the name of the team must end in the word team or in the word group. The rule also originally prohibited the use of the name realty, but the commission reversed that prohibition, and it is now available for use for teams. You can use the word realty, but the team name still must end with team or group. It is not good enough to put the word team or group somewhere within the name, legislation says, and the rule says, it must end with that name. Now, there's no grandfather provisions for teams registered under the previous rule. So if the team name does not meet the new criteria, a revised name which must be registered through the sponsoring broker, and it should be done right away. So we're almost done about names, but let's review who does what. License holders who want to use a name other than the name that's on their TREC license must notify TREC of the new use, and also notice their sponsoring broker. Brokers must register assumed business names using the name management tool available on TREC's website. Now, how the changes get made. The name management tool is a new program on TREC which came out probably sometime in 2018, which permits brokers to register certain names with the Commission, assumed business names, and team names. Agents wishing to file an alternative name or an alias other than a nickname, which is a common derivative, has to register the name with TREC on one of the following forms and also notify the sponsoring brokers of the change. Agents wishing to register a last name other than the last name on their license should use the change of name form to register with TREC and provide supporting documentation and advise sponsoring brokers of the change. So if you are a license holder, a sales agent, who want to use an alternative name, either a nickname or a maiden name, not the last name, the form that you file with TREC is Notice of Alternative Name used by a sales agent or broker license. And down the form number is on the screen. It's ALTNMO-O. And all you do is just fill that out, and I think it says you're supposed to fax it to TREC. And it says, do not use this form for common derivatives of a legal name like Jim for James or Kate for Catherine. So this is if you want to use Skip for Junior or your middle name or hyphenate your name or things like that. Now, if you have a need to change your last name, then you have to file a change of name for license holders. And this form requires supporting documentation. So if you're changing your last name, getting married or getting divorced or whatever it is that's causing it, or you need business documents like articles of incorporation, certificates of organization, anything like that, this is the form that you use. Brokers will take care of registering teams, and brokers will take care of registering assumed business names for the brokerage. But the license holder is responsible for taking care of their own name changes and alternate names, but advising their brokers of what they're trying to do. So, any questions? Okay. I have a question from Kurt. Can you use the team broker associate? Brokers, you cannot use the word associate in a team name, so no, you'd have to end the team name with the word team or group, and you cannot use the word associate in a team name because it seems to indicate that you might have something to do with the management or the company. The alternate name, does the alternate name need to be registered with the county we do business in? No, I don't believe it does. An alternate name is just an alternative name that you can use on your existing real estate license. So thanks for that, and we'll move right along. We're going to talk a little bit now about the advertising rule. It comes from TREC Rule 535.155 if you're into numbers, and the Texas Real Estate Licensing Act, Section 1101.562 B 23. It goes back and begins with what each advertisement must include. The advertisement must include the name of the license holder or team placing the advertisement, the sponsoring broker's legal name or registered business name, and at least half the size of the largest contact information for any sales agent, associated broker, or team name contained in the advertisement. Now, we've been doing that for years. We've had this little thing called a safe harbor, advising us that the broker name must be at least 1/2 the size of the largest contact number for us. Now, with the advent of this legislation, the safe harbor ended, and this rule is now embedded as a requirement. So we just keep doing what we were doing, since the safe harbor is no longer there, and now we have legislation that and a rule that says that what we must do. And the rule also sets out 20 instances, as I said, that identify what advertisements that are likely to deceive the public or tend to create a misleading impression or imply that a sales agent is responsible for the operation of the real estate brokerage business is in violation of the Licensing Act. Let's take a look at those. What is an advertisement? According to the rule, an advertisement is any form of communication on or behalf of a license holder designed to attract the public to use real estate services. Are there any exceptions? Yes, there's one. A communication from a license holder to a license holder's current client is not considered an advertisement. So the advertisement is really just your first contact. This has been kicked around for a long time. Do I have to put my whole email signature block on every email I send my client? According to this rule, you do not. So once you do it once, then you're done on that. Things that might be included as an advertisement: any kind of a publication, brochures, radio or television broadcasts, electronic media, including email, text messages, social media, and the internet, business stationery, business cards, displays, signs, billboards, anything that we give the public to entice them to come use our services. Now, some of the new ones, the ones that really are into the new rule, we're going to talk about 3. An advertisement that uses titles such as owner, president, CEO, COO, or other similar title, email, or website address that implies a sales agent is responsible for the operation of a brokerage. This kind of goes back to when team names were registered as an assumed name of the business, of the broker's business. By moving it to teams, we will remove that kind of a reference. And then an advertisement that contains a team name with terms that imply the team is offering brokerage services independent of the sponsoring broker. And these are the forbidden words: Realty was a forbidden word. It is no longer a forbidden word. The word brokerage, the word company, and the word associates. And team names must end with the word team or the word group. And an advertisement that contains the name of a sales agent whose name is in whole or in part used in a broker's name that implies the sales agent is responsible for the operation of the business. What in the world does that mean? Well, I'll give you an example in a minute about Ellis Real Estate and about how the broker is John Ellis and the sales agent is Corey Ellis, and how Corey has to identify herself so that she is not assumed to be part of the management or the company. Just for a minute, we'll talk about penalties for the non-compliance of this. Remember, there is no safe harbor anymore. These rules have been in effect since last year. And actually the reason why we're doing it again today is because when these rules went into effect, it was September of 2017. And most of the members of our board were very preoccupied at the time with a thing called Hurricane Harvey. And it just seemed like name changes coming from TREC took second place to most of us. So anyway, prior to the legislative change, the penalty read that TREC may suspend or revoke a license or take other disciplinary action if the license holder, while engaged in real estate brokerage, publishes or causes to be published an advertisement, including an advertisement by newspaper, radio, television, the internet, or display that 1, misleads or is likely to deceive the public, and 2, tends to create a misleading impression, or 3, fails to identify the person causing the advertisement to be published as a licensed broker or agent. You see, I've crossed out that number 3 because the legislature said that TREC can no longer require that kind of a reference. So the revised penalty for non-compliance with these rules is the same through number 2. The third leg of this stool now reads, implies that a sales agent is responsible for the operation of the broker's real estate business, or 4, the name may include assumed name or trade name of the broker as authorized by law of this state and registered with TREC. Oh, I read that wrong. Let me try that again. Implies that a sales agent is responsible for the operation of the broker's real estate business, or 4, fails to include the name of the broker for whom the license holder acts, which name may be the license name, assumed name, or trade name of the broker as authorized by the law of this state and registered with TREC. And all that is all what we've been talking about so far today. All right, before we move on, let's take a look at the Code of Ethics. The NAR Code of Ethics does not excuse us from saying our role in the advertisement. It says in Article 12, Article 12, realtors shall be honest and truthful in their real estate communication and shall present a true picture of their advertising, marketing, and other representations. Realtors shall ensure that their status as real estate professionals is readily apparent in their advertising, marketing, and other representations, and that the recipients of all real estate communications are or have been notified of those communications are from a real estate professional. And then TREC cannot require license holders to identify their status in their advertisements, but the NAR Code of Ethics can and does require that we identify our status in our advertisements. So let's talk about some practical situations. Any more questions before we move on? Okay. Yes, there are a few. Can we make the slides available? Okay, will you be making this question here? Will there be a recording provided available afterwards? Yes. Will I be able to use my maiden name as well as my married name, or do I, or will or will I be able to use either one? I'd like to use both if possible. Maiden name for past clients, fine for me, and married name for new clients. That's exactly the point of the alternate name. If you file an alternate name with your new name, your married name, then be sure to send your marriage certificate that says that you are married, and then just file another one that says your first name, your maiden name, and your last name. And that way, TREC can find you on their database either way, and you can use either name. You can use any name that is registered with TREC. Just don't forget to notify your sponsoring broker that you're doing that. Good question. Thank you. Okay, some practical situation. We talked about Corey and John Ellis a minute ago, so let's see what they're up to. Corey Ellis is a sales agent working under the sponsorship of John Ellis, broker, her husband, doing business as Ellis Real Estate. Let's go. It's not working. Enter. Hold on, we got a little technical problem. Okay. If Corey advertises as Corey Ellis with Ellis Real Estate, is her position clear? Would a consumer think that Corey is in charge of the real estate business? Yeah, I think so. Yes, a consumer may think that Corey is in charge of Ellis Real Estate Brokerage. How can Corey make her position clear? Add sales agent after her name. The word realtor won't work in this particular case because the term realtor applies both to people with sales agent licenses and broker licenses. So we want to be sure that the public understands that Corey is a sales agent working under the brokerage of Ellis Real Estate. Okay, Peppermint Patty, a sales agent, wants to advertise under the name Sweet Real Estate as an assumed name or DBA. That possible? A sales agent cannot advertise under an assumed name. Assumed names are available for sponsoring brokers only. This goes back to the exact problem that we had with confusion for the consumer. So what can she do? She can ask her sponsoring broker to register the name Sweet Real Estate as a team name for just one member. The word group or team must be the last word. So teams can be one person or they can be many people. So it's a good alternative for somebody that wants to be advertising under Sweet Real Estate. And here's some more. Kathy Lee's license name is Kathy Lee Martin. She wants to advertise under the name of Kathy Lee Martin. What's the procedure? It says Kathy is a derivative of Catherine. The license holder only needs to advise her broker of the change. Simple enough. Then Kathy makes a decision. She wants to advertise using her maiden name. What do you think has to happen there? A notice of name change must be filed with TREC and her broker must be notified. That's if she wants to advertise using her maiden name as her last name. The commission may ask for legal authority to change this last name. Okay, now associated broker. A name used in advertising other than associated broker's license name must be a team name or an alternate name. It can no longer be an assumed name. And a special note here, using the word broker in an associated broker's advertisement is clearly misleading to the consumer and will cause confusion as to who is in charge of the brokerage associated with that broker. Now, everybody get that? If you're an associated broker, you must identify yourself as such. Don't forget that first part. Okay, now some advertisements to see if they are in compliance. Let's see what you think about these. Here we have an advertisement that says, for sale, new construction, call Kathy Johnson, sales agent, Prestige Real Estate, and a telephone number. Is this ad compliant? You all got your answers? Yes, this ad is compliant. It includes the sales agent's name and the brokerage name in at least 1/2 the size of the largest contact number. I want to add something here that I think everybody might assume but don't know for sure. The requirement for identifying your broker does not include anything other than your broker's name or assumed business name. It does not include having to disclose a telephone number for your broker. Here's another one. Is this ad compliant? It says, for sale, new construction, call Kathy Lee Martin, CEO, and a telephone number and Prestige Real Estate. Is it compliant? No, that is not compliant. It does have the sales agent name and a registered assumed name of the broker in the proper size, but the use of the word CEO next to the license holder's name implies that she is the person responsible for the operation of the brokerage and is inherently misleading. How to make this ad compliant? Delete CEO and insert sales agent. Remember, that is required by Article 12 of the Code. Now, she could probably use the word realtor if she wants. What about a Teams ad? Is this ad compliant? For sale, new construction, call Kathy Martin, the super team. Telephone number at Prestige Real Estate. What do you think? Yeah, it's compliant. It identifies Kathy as a member of a team and has the broker's assumed name in at least 1/2 the size of the largest contact information. Okay. I'm going to go over some frequently asked questions and then we'll take final questions and we'll wrap this thing up. So there's just a few of these, but I thought if you didn't ask these questions that it might be interesting for you to know about them. And the question is, can an associate broker use his or her own assumed name in advertising? No. An associate broker can have an assumed name because he's a broker. But a name used in advertising by an associate broker under a sponsoring broker that is not the associated broker's license name must be registered as a team by the broker. he or she is associated with and meet all the requirements of a team name. That makes sense? So associated brokers function just like a sales agent when it comes to registering and advertising. Can an individual sales agent use an assumed name in advertising? Absolutely not. Any name used by an individual sales name other than the name on the license or registered alternative name is considered a team name under TREC rules and must meet the team name requirements, such as it must end in team or group, and it is not an assumed business name that is reserved for brokers. I am a sales agent. Can TREC review my advertising and advise me whether my advertising complies with TREC rules? Unfortunately not. TREC does not review a sales agent's advertising. TREC will only discuss advertising questions with a broker directly. Your sponsoring broker should review your advertising because your sponsoring broker is responsible for ensuring that your advertising complies with TREC's advertising rules. Your broker must maintain, and your sponsoring broker can be disciplined, by the way, if your advertising violates TREC rules. Your broker is responsible for you doing it right. Your broker must maintain also on a current basis written policies and procedures to ensure that each sponsored agent complies with the commission's advertising rules. So if you have a question about whether your advertising wants and needs meet TREC's requirements, take it to your broker first, and if it's still confusing, your broker can call TREC and get the answer for you. So that ends our presentation for today. We'll check one more time for questions. I'm checking now if I can get to it. I'm checking, hold on. Doesn't look like there's any more questions. If any of you have any questions and want to speak to me personally or privately, my contact information is on the screen. So if there's no other questions, we'll bid you adieu. Thank you for tuning in, and please let us know if you have any questions.